Good morning, everybody, and thanks for coming. I'm June Bessick, the Executive Director of the Kernochan Center for Law, Media, and the Arts, and we are especially grateful to those of you who plan to come in November, and then that was postponed and still came today, so we really feel very grateful to you. This is our symposium on copyright exceptions for libraries and Section 108 reform, and we are doing this in cooperation with the U.S. Copyright Office, and I thank Maria and Chris and Karen for all the work that they put into this as well. I want to thank our sponsors, the Harry J. Rudick Fund, the Horace Manges Lecture and Conference Fund, and the Columbia Journal of Law and the Arts. Just so you know, we are going to be recording the session, and then the webcast will be available on our website, the Kernochan Center website, and then the proceedings will be transcribed, and the journal is going to publish them. Just a few logistical things. The schedule we've changed the schedule because we realize how hard it is for everybody, and it's such a really miserable day. So Pippa and Cindy are going to pass out the revised schedule, and that will have us done by about 3. One of the big changes we're going to make in the schedule is we're cutting lunch down to half an hour because we're going to bring lunch in for everybody. So you don't have to go out in this weather. And so that means if you can get up, get your lunch, and then sit back down and continue to eat while the next panel starts, and that'll keep things moving along. The restrooms are directly across the hall if you haven't, well, actually directly across here if you haven't been there yet. And there are 2 entrances to this room, so sometimes there's a roadblock at that entrance, so just keep in mind there's this entrance as well. I want to thank Pippa Loengard for all the work that she did putting this together, and Cindy Tangora, the program coordinator for the Kernochan Center, who's done a terrific job, and also Shira and Megan, who do our events coordination, who have done a wonderful job in trying to, reschedule stuff at the last minute, and we're really appreciative of that. If you're seeking CLE credit, don't forget to sign in and out in the morning and in the afternoon. A couple other things. Normally, Columbia has a firewall up, so you can't access our Wi-Fi, but we've arranged to have it taken down for today. So if you have problems, please let one of us know. Most of the material is on our website. It's law.columbia.edu/Kernochan. But we did put Section 108 in your packets because obviously we're going to be talking about it, and it's a lot easier to have it right in front of you. We're going to start with Session 1, which is different in format from the other sessions, which are roundtable discussions. And we're going to keep our introductions quite short so they don't take up a significant part of our time, especially with our shortened schedule. And there's more information on all the speakers in your packet, so you can study it at length if you like. All right, our first session is the legal landscape. We have 5 speakers, and we will leave plenty of time at the end for audience questions. I'm going to introduce the first 3 speakers.
We're out of programs, more are coming, so if you don't get it, don't get it.
Okay. That's weird. But anyway, so I'm going to introduce the first 3 speakers. They'll just turn the podium over to each other, and then when Jane finishes, she will introduce our second 2 speakers. So our first speaker is Maria Palante, the U.S. Register of Copyrights. And she's been the Register since June 2011. Prior to that, she served as Associate Register and Deputy General Counsel. And for several years, she was legal counsel to the Guggenheim Museums. Then our second speaker is Shira Perlmutter, who's the Chief Policy Officer and Director for International Affairs at the USPTO. Prior to that, she was the Executive Vice President for Global Legal Policy at the International Federation of the Phonographic Industry, IFPI, and she's also served both in the U.S. Copyright Office and at WIPO. And then our third speaker will be Professor Jane Ginsburg, who's the Morton L. Janklow Professor of Literary and Artistic Property Law here at Columbia. She's the author of several books and numerous articles on copyright law. So with that, I'm going to turn it over to Maria.
Thank you, June. Good morning, everybody. I too want to thank all of you for coming out in this weather, both the participants and the audience, and just a huge thank you to the Kernochan Center at Columbia Law School for organizing this not once but twice. And I'd like to start just by making a rather obvious statement, which is that when we talk about 108 reform, what we're really doing is affirming the critical importance of libraries and archives and as you'll hear later today, museums in the copyright system. Without these institutions and the professionals that they employ, scores of creative works would not find an audience. Books, music, letters, films, and other essential documents of our civilization would be uncollected or unorganized, or both. And people who may not have the means to purchase cultural materials would not be able to fully participate in our democracy. It is because of this centrality to the diffusion of knowledge that libraries and archives currently enjoy an exception in the copyright law. Section 108 is a recognition that regular and frequent reproduction and distribution of creative works is vital to the mission of libraries and archives, vital enough that subjecting these activities to the application and uncertainty of fair use should be unnecessary. Fair use is, of course, a critically important doctrine. Many of you know that the Copyright Office was very centrally involved in the codification of fair use in the 1976 Act. It also played a major role in the codification of Section 108. And as you all know, these provisions have lived alongside of each other ever since, and in the view of the Copyright Office should continue to do so. So today, there's no question that Section 108 is woefully out of date. And that's not merely, I think, a frustration for libraries, archives, and museums, but an actual obstacle to the work of preservation and access. And so, as we see it in the office, there are three options. Keep Section 108 as it is, whereby the office fears that it will become an increasingly useless appendage to the Copyright Act, a provision of exceptions so narrowly tailored to bygone technologies that it will be functionally irrelevant. Repeal Section 108, leave library and archives and the activities that they employ to be governed by fair use, which the office feels would be unfair to both libraries and librarians and archivists, as well as to copyright creators and copyright owners, all of whom should be able to rely upon some concrete, unambiguous exceptions without having to consult an attorney or risk an infringement action every time an archivist makes multiple preservation copies or a librarian copies a fragile book for interlibrary loan. Or reform Section 108 so that it provides a balanced certain set of exceptions, updated for the digital era, that allow libraries and archives and museums to make the copies they need and distribute those copies in ways that do not unduly harm the valid interest of rights holders. Many of you know, and you'll hear soon, from 2005 to 2008, the Copyright Office co-sponsored a study group along with the National Digital Information Infrastructure and Preservation Program at the Library of Congress. The Copyright Office has reviewed the report in great detail, and last year I reconvened the group for a day-long discussion as the office formulates legislative proposals on Section 108 reform. It is very likely that we will adopt and recommend many of the conclusions of the study group, but we will also address issues that were left unsolved by that group. Today we'll be talking about Section 108 reform both at the macro level and the micro level. On the micro level are the specific exceptions and how they should or shouldn't be amended. For example, the number of copies allowed for preservation and replacement copying, the need for additional exceptions allowing preservation of publicly disseminated works and internet content, digital distribution of copies made at a user's request, such as for interlibrary loan, and how to best condition the new exceptions so that what is intended as a safe harbor for legitimate scholarly research and private study does not drown the incentives to create and disseminate new creative works. On the macro level are the questions of what the ultimate purpose of Section 108 should be, and how does reform of the exceptions for libraries, archives, and museums affect other pending issues such as the legal framework for mass digitization and for orphan work solutions. So with that, I just want to say we're very pleased to have this dialogue today. This is part of our stakeholder outreach, and we have no doubt in the office that we're going to have much to consider by the end of today. Thank you, and I'd like to now turn it over to my colleague, Shira.
Technology is deceptively less simple than it looks. Well, I'm also delighted that we all weathered the storm and the difficulties that the weather has thrown up in our faces and trying to grapple with Section 108 to be here today. And just to say that this is obviously a very important issue, and as we watch the role of libraries and archives evolve and increase and look to take advantage of the exciting opportunities that digital technology presents, it is very critical for us all to be here trying to find some solutions. Obviously, it's been a long path to get here. We took the first step with the DMCA amendments to Section 108, but they were just baby steps. And then, as Maria was describing, there were several years of intense work by the study group, and it has been years. It's already been 4 or 5 years since the study group's recommendations. So we at the USPTO very much welcome the Copyright Office's renewal of this project and an attempt to reform Section 108. I think this is an important part of what should be an overall effort to look at the Copyright Act as a whole and to decide what elements in it need updating in various respects, and we are beginning to engage in that process within the administration as well in collaboration with the Copyright Office. What I will do in my few minutes is to focus on the international dimension of the issue, and there's been a lot of attention on what exceptions should be for libraries and archives in the digital age in countries around the world and also at WIPO. So to start with, just a few observations about the relationship between Section 108 and fair use as applied to libraries. Now, obviously, fair use is a fundamental underpinning of the balance in copyright law, and it is a doctrine of great beauty and also great weakness, depending how you look at it. The beauty is its flexibility and the fact that it has been able to survive for more than a century in good shape and still apply to every technology that's thrown at us or at it. The weakness is its uncertainty and unpredictability. And on the other hand, the value of having a specific exception like Section 108 is the fact that it is specific and it does spell out in detail terms and conditions that people can rely on and as Maria said, don't need to accept the invitation that fair use proffers to go hire a lawyer to try to guess whether certain conduct is permissible or not. Now, to my mind, what we have in the United States, which is the combination of the specific exception and the flexible general fair use doctrine, is the best of all worlds. If we have both of them, and if we appropriately update the specific exception as technology moves along, we can have a situation where we have the best mix of flexibility and certainty and room to maneuver for the future while giving people some guidance. And of course that requires that both be properly interpreted, and by properly interpreted I mean we need to have a situation where the specific exception doesn't rule out the application of fair use in appropriate circumstances. So I would say both of those elements are critical. Now, in other countries, they don't have a fair use doctrine the way we do here. Some are beginning to enact fair use exceptions, but of course they don't have the history and the precedent that we have in the United States. So I would say there's nothing really comparable anywhere at this point. And in most countries that deal with libraries and exception and archives in their copyright law, they do so through a specific exception. But there are a fair number of countries that don't have either a general exception or a specific one, and the latest WIPO study, I think, listed 21 countries that don't have exceptions addressing libraries and archives. In a number of other countries, there is work ongoing to look at how their laws should be updated in this respect. And I know in particular I had the privilege about 2 years ago of going to the British Library in London and being taken to see their phenomenal sound archives, where they had sound recordings of interviews with famous people, of the sounds made by obscure birds in Latin America, just a phenomenal trove of material. And the problem they were experiencing at the time was that under UK law, it was not permissible to make a digital copy for preservation purposes, and a lot of these recordings were quite old and rare and not likely to survive forever. So that was a big challenge in the UK. And what we're seeing is, as many countries start to think that they need to have exceptions for libraries and archives or to update their existing exceptions, many of these countries don't have the experience and expertise in dealing with new technologies that we have here. So that complicates the task for them. At international level, there's a fair amount of activity. And just to point out that what we do here has a tremendous influence everywhere in the world, regardless of any international discussions at WIPO. Our law serves as a model for the world, especially when we deal with new technologies, because they do tend to get developed and adopted here very early, if not first. So, in fact, we were just having a discussion in my office the other day about the fact that in China, something like 98 or 99% of patents granted and patents litigated are owned by and litigated by Chinese nationals. So the patent system in China is very domestic, in a sense. And yet, China is always very interested in knowing what the U.S. is doing in our intellectual property laws, including patents as well as copyrights, in large part because we are seen as a country at the vanguard of new developments and with a state-of-the-art intellectual property regime. In addition, there is specific work ongoing at WIPO in the Standing Committee on Copyright and Related Rights, and that includes a specific agenda item on exceptions and limitations for libraries and archives. In terms of the timing of that discussion, the next meeting will be in July, where this will be on the agenda. There have been a number of documents already produced that contain within them various countries' proposals and some thoughts for consideration from some countries, some specific language proposals from others. If you go to the WIPO website, you can find all of those documents. And this issue will be taken up. It's still being discussed in an ongoing manner at these meetings, but the first priority at the moment is a diplomatic conference in this June, scheduled for this June, on exceptions for the visually impaired. And then there's also work ongoing on a treaty for broadcasters, but this is teed up and is already on the agenda and is already being discussed as well. Now, one of the questions at WIPO is, what are we talking about as we look at the issue of exceptions for libraries and archives? And there are a number of countries who are interested in putting forward another treaty at WIPO with minimum required exceptions in this area. And other countries are talking about looking at this through other techniques, possibly through joint recommendations, possibly through model laws, and that issue is still very live. One of the aspects that's interesting is some of the countries that are pushing the hardest for a treaty as opposed to a model law or recommendation are countries that don't have any exception for libraries and archives on their books. And some of these countries find that it is easier for them to enact legislation domestically if there is first an international treaty on the issue, which is the exact opposite of the U.S. approach, which is we don't want treaties that force us to change our domestic law. So it's an interesting dynamic. The other interesting part of the dynamic is that, by and large, European library associations have been pushing for a treaty, whereas that has not been the approach of the American library sector. Now, I think from the perspective of the U.S. government, our main concern is we want to be sure that we can influence the content and get a good result in the WIPO discussions. Now, approaching this issue through a specific exception as opposed to something that looks like fair use at international level is much more feasible, because most countries find that a general fair use exception, especially if they're not common law countries that are used to following judicial precedent and interpretation, is a more difficult approach or not necessarily doable or easily adoptable in their legal systems. From our perspective also, a specific exception can provide better security against improper interpretations or abuse in countries that don't have as well-developed legal systems or judicial systems. But above all, I think from our perspective as we join in the international discussions, we really need a state-of-the-art Section 108 to be able to play the role we would like to be able to play. And that's important for us to be able to continue to act in a leadership role in the international discussions. It's important, I think, for right holders when U.S. right holders' works are used abroad to make sure that they're appropriately treated. And I think it's very useful for the library community globally in developing common policies and approaches to their work. And I think that can facilitate their ability to work together, to lend across borders, and to access each other's collections. So, just to conclude, I think it is important to decide in this country what we think works best in light of evolving technologies, to keep in mind that this is part of a broader international picture, and then to be able to come up with some solutions that will allow the U.S. to lead appropriately. So thank you.
Good morning, and I join in thanking everybody for braving the weather and proving that our symposium is not, in fact, totally jinxed. So I'm going to continue on the international theme, but beyond Section 108 to look at what are some of the developments occurring abroad that address what Maria referred to as kind of the macro question, not only what does Section 108 do, but the looming orphan works problem and the even more looming mass digitization problem, both issues which exceed the scope of Section 108, but which are clamoring for some kind of resolution. First, with respect to orphan works, I'm going to talk about the recent directive promulgated by the European Union last fall. And then with respect to mass digitization, I'm going to talk about a French law that was enacted unanimously, which is quite remarkable for France or anywhere, last March, which still awaits its regulatory decree of application, which will be necessary to resolve a number of well, let's put it this way. The devil is in the details, and when I explain the law, you'll see why, and perhaps why we still don't have a decree of application. Starting, however, with the EU Orphan Works Directive, keep in mind the attempts in the U.S. in 2006 and 2008 to have some kind of orphan works measure here. Those will serve as a basis of comparison for the EU effort, which is much more circumscribed. Our attempts, at least so far, would have been general with respect to their subject matter, and most notably would not have been limited to non-commercial users. And the U.S. version of orphan works also offered or endeavored to offer some level of detail with respect to the diligent search necessary before work could be considered to be an orphan work. And of course that detail turned out to be extraordinarily elusive. The EU has gone about it a little bit differently. The directive limits the subject matter of orphan works to books, films, phonograms, and broadcasts. In other words, not photographs. And of course, the gorilla in orphan works is photographs. Photographs are only covered to the extent that they are included within books, but separate photographs are not included. This is all material that is in the collections of public libraries, museums, or broadcasting entities. So again, the universe is further circumscribed and first published in a member state of the European Union, thereby to avoid some of the questions of whether or not this measure complies with international norms. The definition of an orphan work provides that it is one for which no right holder can be found despite a diligent search, but diligent search isn't really defined. Rather, the task is delegated to member states to develop the contours of what is a diligent search in consultation with representatives of the interested parties. A key, however, for all of this is that there be a system for maintaining records of diligent searches and a centralized database that will permit subsequent would-be users of orphan works to consult that database. Another important feature of the EU directive is that the diligent search is undertaken in the country of origin of the work. This is assuming one can ascertain the country of origin of the work. And if it is considered to be an orphan work in the country of origin, that status will be recognized throughout the European Union. So for all 27 member states, you don't have to do a diligent search in 27 states. You do a diligent search in the country of origin. That will be recognized throughout the EU. And what the user is entitled to do, remember that the user is a library, museum, or public broadcaster, is to make available and reproduce those works, but only for non-profit purposes. And an additional feature, which would be nice to have in any legislation that we ultimately have, is that in all instances the author's name, if it is known, must be included on all disseminations of the work. So the member states have 2 years to adopt implementing legislation, and we'll see what happens. But this endeavor, which was not uncontroversial as it was going through, is, because it is so circumscribed, it's not clear how much good it's going to do, because in many respects the whole orphan works debate has been overtaken by the mass digitization debate. And mass digitization is fundamentally different from orphan works. Orphan works requires a diligent search, and as the directive specifies, work by work diligent search. That's a lot of transaction costs, and if you want to make available a large quantity of works, may ultimately be defeating. And as we know in the premier example of mass digitization, perhaps extra-legal mass digitization, Google did not seek anybody's permission ahead of time, did not take any kind of search, diligent or otherwise, in order to ascertain the status, notably, of out-of-print in copyright books. The Google Books controversy was controversial not only here, but also in Europe. And a number of European countries were distressed, not only their authors and publishers, but also at a higher level, they were concerned that Google was taking over their national culture, and they had better be able to do something about that. So the French legislature in March of last year, so almost a year ago, enacted a law which was widely perceived of as the anti-Google law, or the French answer to Google. And this is known as the law on unavailable books, and it is specifically for mass digitization. The universe of books, only books concerned, are books published in France, again to avoid the international problem. Before 2001, the presumption is that anything since 2001 is already available in digital form. So a French book published before 2001 and not currently on sale or otherwise available, whether in print or in digital. So those are those out-of-commerce books. The National Library is appointed to create a database. It's not entirely clear from the text of the law whether the National Library also is appointed to do the digitization. That, I suppose, will also be made clear in the famous but so far unpromulgated application decree. The database will consist of all these unavailable books, and it can be crowdsourced. So it's not just the National Library that will generate this list, but anybody who thinks that he or she has identified an unavailable book can contribute the listing to this database of unavailable books. When that database is published, the authors and publishers will have 6 months to opt out. If they do not opt out, then a collecting society created by this law is appointed to grant on a non-exclusive basis the rights to anyone. So it's not limited to non-commercial, and it's not limited to libraries. Rights to anyone to make available, to exploit, to publish, distribute, and so forth, for 5 years renewable. The licensee will pay a remuneration to be fixed, that's another one of those details, to the collecting society, and the collecting society is supposed to distribute the proceeds 50-50, at least 50-50 to the authors. It's possible the authors might get more, but they have to get at least 50% of the proceeds. Now, if the authors or publishers opt out, this is where it gets more controversial still. The publisher can opt out, and in which case it has 2 years to exploit the work, and if it doesn't exploit the work, it goes back into the generally available pool for anybody. The author has more than that 6-month period to object, but only on moral rights grounds, on the ground that the exploitation of the work would be deleterious to the honor or reputation of the author. I'm not sure what that will mean in practice, if it means that some juvenile work that the author doesn't want disseminated. I don't really know how that will actually work out. But if the publisher does not opt out in the 6-month period, this collecting society, before it offers the general license, has to offer the print publisher an exclusive license for 10 years, automatically renewable, to exploit the work. Now, this is the part that I find rather curious, because if the publisher never got the digital rights, it doesn't help the publisher to opt out, because the publisher can't publish within 2 years if the publisher didn't have the digital rights. But instead, the publisher can wait, get the first crack at exclusive digital exploitation of the work, and then proceed, never having got the digital rights from the author. So this is really quite remarkable. The author can object, but only if the author proves either that the publisher didn't have the print rights, but that's not relevant. The relevant is the digital rights, not the print rights, or that the author is the only person with the digital rights, which means that in the case of any ambiguity as to whether the author gave up or didn't give up digital rights, the publisher wins. This is the part that I find, and many people somewhat belatedly discovered was somewhat regrettable in the law. So we'll see what that famous pending application degree does. But I would suggest that what the French did was they were in a hurry to come up with an anti-Google law, and they didn't really work it through. That's the nice explanation. The not nice explanation is that this is a cabal of the print publishers to get the digital rights they never got. Oh, I'm sorry. Right. So I was so intimidated by the stop sign. So it is now my pleasure, as we turn back to Section 108, to introduce the two chairs of the Section 108 study group. First, Dick Rudick, who retired in 2004 as the general counsel of John Wiley and Sons. He has worked in the publishing industry for more than 30 years, and he is also a former vice president of the International Publishers Association. Following Dick, Professor Lolly Gasaway, co-chair, will speak as she is the Paul Eaton Distinguished Professor of Law at the University of North Carolina School of Law. She was a law professor and director of the Law Library for more than 20 years, and from 2006 to 2010 was the Associate Dean for Academic Affairs at the University of North Carolina Law School. So, thank you very much.
I've got a slight cold, so if a frog jumps out of my throat, that's the reason. I want to begin by reading to you a quote from Hermann Hesse, which I read in the first meeting of the Section 108 study group. Of the many things which man did not receive as a gift from nature, but which he created with his own spirit, the world of books is the greatest. Without the writing of books, there is no history, there is no concept of humanity. And if anybody wants to enclose in a small space, in a single house, or a single room, the history of the human spirit, and to make it his own, he can only do this in the form of a collection of books. Now, I've never actually read anything by Hermann Hesse. I just know this. I just know this quote, which I love. That room, I think, must be a library, and its precious contents are the subject, or should I say the objects, of copyright. And these words, I think, are very relevant to our work today. First, because they remind us of how much libraries and their collections have changed, from a collection of books to a vast array of media, much of it born digital, and, very importantly, from a room or a building to interconnected systems spanning a campus or state without physical walls. Second, they remind us that everyone in this room, librarians, teachers, students, scholars, writers, publishers, media producers, people who just read, all of us who have a stake in copyright, we live together in Hesse's wonderful room, that we have a self-interest in collaborating to make that room light, full, and spacious, that our most dangerous enemies are not each other but the Philistines, those who do not value the world of books. The study group was convened in 2005 by the Copyright Office in the Library of Congress. I think of it as the brainchild of the then Register of Copyrights, Mary Beth Peters, who for some reason is sitting in the last row. Roughly half of us came from the library and museum community, half from the content and creative community. We completed our work in 3 years, by 2008, proving in the words of Gypsy Rose Lee that anything worth doing well is worth doing slowly. Our mission was to re-examine the exceptions and limitations applicable to libraries under Section 108, which, I remind you, was written largely to deal with the then exciting new technology of the photocopying machine, and to make balanced recommendations how those provisions could be made relevant and workable in light of the impact of digital technologies as those and equally important, the ways we use those technologies had evolved and matured over the intervening years. Our working style was based on the idea that if people of goodwill with differing perspectives could listen to each other and talk to, instead of as we usually do, at each other, they could make progress towards agreement on how to fulfill that mission. And the result was a series of recommendations, which Lolly will shortly review, for updated and enhanced exceptions. The recommendations reflect unanimous consensus on the underlying fundamental principles, which says something about the value of creating an environment which facilitates, specifically designed to facilitate thoughtful discussion. And it also says something about the commitment and sincerity of Lolly's and my colleagues. But the study group's report records not only agreements on fundamental principles, but disagreements based on fundamental tensions. We agreed quid pro quo that with updated exceptions would come increased responsibilities arising from the need to reasonably protect copyright owners from the dangers and potential abuses of the digital world. We agreed on those responsibilities and how they might be implemented in some cases. On others, we did not resolve our differences, and we recorded the disagreements as carefully as the agreements because they're just as important and because they have to be addressed if we're going to get home. I'm going to briefly mention a couple of things which Jane has touched on, well, more than touched on, which were not addressed in our recommendations. Mass digitization, which we'll get to in session 3, and something Jane, I think, mentioned very briefly, the question of whether exceptions should distinguish between works which are commercially available in the marketplace and those which are not, which could come up in session 4. We decided in 2005, after some discussion, not to address mass digitization, believing, I think reasonably, that the time wasn't ripe. I might also add that we didn't think 3 years was enough. It's 2013. The time is certainly right. It's true that Section 108 is not the only way, not the only place to deal with mass digitization. Maybe it needs to be dealt with in more than one place. But you can't, I think, talk about how you would frame an ideal library privileges section without thinking about the mass digitization. We did discuss whether commercialization or commercial availability should be a benchmark for purposes, or at least for some purposes, of Section 108. For reasons which are not entirely clear to me now, we found this very difficult, and we did take a pass. The parties to what I like to call the Google Book non-settlement agreement found this distinction to be a lot less difficult. In fact, content owners, at least certain types of content owners, print publishers, seem to feel comfortable about making that distinction. And that, along with developments in Europe, which Jane mentioned, suggests that we should really take a look at whether and when commercial availability should be a factor. It's been noted earlier, I think, that I think Maria mentioned that because Section 108 has been so out of date for so long, libraries have reasonably come to rely more heavily on fair use under Section 107. And, of course, the question is asked, and will certainly be discussed today, do we need Section 108? You know how Maria feels. The members of the study group felt the same way. We did address that question and pointed out in the report that a provision so outdated and inadequate as to no longer serve its function invites disrespect for law. One might add that it invites expensive litigation with uncertain results, and one might add also that the doctrine of fair use as codified in 107 is not well suited to addressing many of content owners' concerns, such as securities. And of course, Shira mentioned the international considerations. Finally, and I think this is the most important reason, from a practical standpoint, an up-to-date and balanced Section 8 would complement the flexibility of 107's fair use provisions and would provide straightforward guidance and clarity in a number of important specific situations. Clarity is the handmaiden of certainty, and an important function of the law is to provide rules which, if followed, keep us out of trouble. Oliver Wendell Holmes Jr. once observed that, quote, certainty generally is illusion, and repose is not the destiny of man. I am certain enough that repose is not your destiny, and that absolute certainty is generally an illusion, but a level of certainty is a prerequisite for doing business, whether your business is that of a librarian, a teacher, or a student, or a publisher, a writer, or an artist. And this was the reason that the study group in its report urged you to consider the merits of a Section 108 for the digital world. That concludes my remarks. Lolly?
Good
Good morning, and thanks to all of you for being here and to Columbia for hosting this. I found out I'm the only one using slides. Not sure why, but... Okay. No, I'm not on there yet. That's what I'm... There we go. There we go. So we have to have a tiny technology glitch to begin to talk about technology, I guess. The 108 Study Group report really consists of 5 types of material, that very long document. First of all, we have background material about the legal landscape. We have recommendations for legislative change. We had conclusions on other issues. We had additional issues that we discussed, and bunches of appendices with statutes and all kinds of materials in it. So it is a long and comprehensive report. First, I want to look at the recommendations with you. And the first recommendations deal with who is eligible to take advantage of the Section 108 exceptions. Currently, it's libraries and archives that meet certain criteria that are able to take advantage of it. And the first thing we wanted to do, or that we thought now made sense, was to include museums in that group of organizations that could take advantage of whatever the exceptions were to be. Now, in order to do that, we would have some additional eligibility requirements. For example, a public mission, a trained professional staff, professional services that are typical for libraries and archives, and a collection that is lawfully acquired or licensed. So adding to the sort of requirements that already exist in 108. Another important recommendation was to permit libraries to outsource the covered activities. But in order to do this, there are some important conditions. For example, the contractor that's acting must be acting solely as a provider and not for other direct or indirect commercial advantage or benefit to that contractor. The contractor could not retain copies. For example, if they were doing the digitization, they need to be doing it just for the entity. And then there would be required to have an agreement between the parties that would permit rights holders to obtain redress for infringing by the contractor. Then we move to looking at some specific sections. And I'm actually going to start with subsection C because that is the more common section, even though it's not the next one in order. Currently, section C we refer to it as the replacement section, and it permits the making of up to 3 copies to replace a lost, stolen, damaged, deteriorated, or obsolete copy. And in the Section 108 group, we begin to call those the triggers. What's the triggering event? It applies only to works that are already in the library or archive or museum collection, and you must first make a reasonable effort to obtain an unused copy before you're allowed to reproduce it. The Digital Millennium Copyright Act added the ability to make digital copies, but any digital copy has to be counted in that 3 maximum and cannot be used outside the premises of the library. That's a hard definition if you go back to what Dick was saying about how libraries are no longer just one physical building, but maybe a campus, may be larger, etc. So we begin to look at this. And here are the recommendations dealing with the replacement section. First of all, change the 3-copy limit to a reasonable number of copies. The idea is it may take many copies to get a usable digital copy. We wanted to add fragile as a trigger. It may not yet be completely damaged, but it's on its way. We also recognize that you need to be able to allow certain digital copies to be used outside the premises of the library if what you are digitizing as a replacement had been able to be used outside the library. So we're really talking about DVDs, CDs, etc., that have a tangible form but are digital. We recommend changing the requirement of an unused copy to a usable copy, because today it's much easier to search the used book market than it used to be. And then that fair price would be determined on a case-by-case basis. So that's the recommendations that for most of us would be dealing with for replacement of works. Subsection B is the preservation of unpublished work. So this hits predominantly archives and wood museums, libraries to some extent, but the published work is a larger issue for us. The current section allows making up to 3 copies of an unpublished work for preservation, security, or deposit for research in another library or archives. Again, it applies only to works that exist in the collection. And the DMCA also added the ability for one of those 3 copies to be a digital copy, but again restricted to the premises of the library. Now, to me, this one always made more sense because of the author's right of first publication than did the restriction in the published work piece. But nonetheless, that's just my personal thing. So our recommendations for subsection B is to change again the 3-copy limit to a reasonable number of copies, to allow deposit of a reasonable number of copies, but only the library that owns the original has that right to reproduce. And the deposit recipient can hold the copy and have it a used copy, but doesn't get the further right to reproduce. This really pretty much tracks what's in the current section, but adds the digital. And we would add the same off-site lending changes if the original work was an unpublished audiovisual work that could be lent outside the institution, then so could the preservation copy made under 108B. Then we have 2 sections that would add new to Section 108. The first one we dubbed the preservation-only exception. And it would apply to at-risk published or publicly disseminated digital works. We recognize that when these digital works are acquired by libraries, you have to preserve them then. You can't wait until they're already damaged or deteriorating, because by then it's too late. You can no longer preserve them at that point. So no requirement of prior loss or destruction, no requirement to search for a usable copy. Typically, we would assume the preservation would be digital, although there could be a library that would decide to do print copies, but we don't think that would happen, but could happen. Again, a reasonable number of copies to obtain the digital copy that's usable, restricting access to staff necessary to preserve the work, and any preserved copy would be labeled as such, that it is a preserved copy. There were also criteria added in order to qualify to take advantage of this preservation-only exception. For example, you would have to maintain preserved copies in a secure, managed, monitored, best practice environment. You'd have to have transparent means to audit the practices. You need a robust storage system with backup copies, and probably most importantly, the ability to fund long-term preservation. Standard security. But there is, within the recommendation, an allowance for smaller institutions with limited resources to deal with digital copies that are unique to their collections especially. And one that Dick was saying to me as we were sitting up here was his favorite recommendation is the recommendation to be able, did I go too far? No, wait a second. There. The recommendation to preserve websites. Right now, there is nothing in 108 that would allow a library to curate a collection of websites, and yet we recognize that this is where much of the important material is being collected. I could think of one maybe for this area that deals with weather disasters of 2012-13 that a library might want to collect, so that if we ever have other weather disasters in this area, we have some of the material available. This would be limited to publicly available and publicly disseminated online content that is not restricted by any kind of access controls. The recommendation is that there would be a period of embargo, for example, a year, 6 months, something before the library library could then make it available to users remotely. Owners would be able to opt out, but not if the owner is a government or a political website. We would try to have this so that it would respect robots.txt or other similar commands. One of the important restrictions is that preserved content would have to be labeled as such so that a user would know this is not the current website. This is a preserved copy of a website as of a particular date. We had some miscellaneous recommendations that hit other sort of more minor provisions in 108. For example, expanding the TV news exception that is found in Section 108F3 to permit streaming for view-only copies. Not downloadable copies, but view-only copies. And we need to update the unsupervised reproduction equipment notice in Section 108F1 so that it would include that the library or archives or museum is not responsible if a user uses their own personal reproduction equipment, now to include iPhones and other smartphones, in addition to people who have scanners, etc. And that notice would say copies made by users need to recognize that it is subject to, making a copy is subject to the copyright law. And then we need to reorganize 108. We also have some conclusions that don't know how I still had a little animation left in that one, sorry. We had some conclusions on which we did not reach a recommendation, but had some agreement. For example, digital copies for users that are obtained, for example, such as interlibrary loan or direct copies for users. These would be under subsections D, E, and G2 for those of us who are Section 108 geeks. We would allow digital distribution with sufficient multiple copies to provide a user with a single digital copy, but we would also have to have adequate protection measures in order to allow that. This would be a much more flexible standard than the current 108. Another conclusion, but with no recommendation, is subsection 108I is really a problem, which limits the section basically to text works except for preservation and unpublished works, and for that TV news exception. Other than that, it's a text section. And what we're finding is we're getting more multimedia kinds of material that have text but also have other things embedded. And we need to find a way to amend that section so that it's not just a text-based section. So maybe we need to repeal this section or perhaps parts of it. But we would require certain conditions to address the problems inherent in reproduction and distribution of these works to protect copyright holders. Then there were a lot of other issues discussed on which we did not reach any conclusion even. For example, do we include virtual libraries, archives, and museums? Talked about that a lot. What about performance and display of unlicensed digital works? Of course, we had to talk about licensing a bit. Circumvention of technological protection measures, the Section 1201 stuff. We talked about electronic reserves. We talked about the pre-1972 sound recordings. June's baby. And we talked about attorneys and cost, aligning sections 505 with 504C, but we didn't reach that. There were lots of the other things we talked about, like state immunity, all kinds of things. One thing we did not talk about, as Dick said, was the Google Books issue. It was pretty new at that time, and it was always referred to as the 1,000-pound elephant in the room. We didn't know what was going to happen with it from 2005 to 2008. It was going on, but we sort of thought that was outside of the scope of what we were doing. So those are the recommendations in a quick nutshell, and thank you very much.
First, I want to thank all of the panelists from this morning in the first session, and then I want to open up the floor to questions. We've got about 20 minutes for questions, and I would just ask that when you are called on, could you turn on your mic? You have the ability to turn on the mic in front of you, and even more important, when you're done, please turn off your mic, because you probably only want certain things to be broadcast to the room. So let me just open the floor. Who would like to ask questions? Yes.
I'd like to ask regarding electronic reserves. You say that you don't have any conclusions exactly, or nothing is fixed. Where do you see this going, especially in light of Georgia State?
Who is it addressed?
Is that addressed to anybody in particular?
Whoever feels that they have enough information to speak.
Also, could I ask you to identify yourself and all the questioners, if you could?
Absolutely. My name is Stephanie Gross, and I work at Yeshiva University in Electronic Reserves.
One of the things with 108 that we really looked at is whether reserve should be a part of 108 and not be a part of 107. And we had some discussion on that, but finally determined that we would not make a recommendation to move it, which meant if it stayed in 107, it was outside the purview of our charge, which was to look at 108. Where do I think it's going? Wish I knew. Wish I knew. Sorry.
Just to add to that, one of the things we decided was that we had limited time. We didn't know we had 3 years. I think we planned to take 1 year. And so we just made a big list of things which were very important. Somebody said this is part of a need to overhaul our Copyright Act. And 108 isn't the only thing, maybe, that we need to look at. So in part, it's a question of what's wrong with 108. It's also a question of what's the right place to deal with things. And we just took some things off our list because we thought if we're going to get agreement, we need to concentrate on what's absolutely essential. But it's a very good question.
Other questions? Yes, back there.
Doug Farrelly from Arizona State University. I'm the media librarian there. In addition to this multi-year process of reviewing Section 108, there's also been a Mellon Grant project to look at videos at risk and make recommendations regarding Section 108. To what extent are those recommendations being incorporated into the study group's recommendations for Section 108? Thank you.
Section 108 study group is disbanded. I mean, we completed our work with the submission of the report. So I think the Copyright Office may now combine these things, but the study group itself is done.
Yeah.
In the Library of Congress, there's the National Digital Information Infrastructure Project. Maria's probably a better person to talk about this, but there really is an ongoing program, and it involves, I mean, this is so complicated. Everybody worries about, we used to worry about paper, how to preserve paper, which it turns out is relatively simple. You can argue that legislation is just one of two or three or four different difficult sets of problems we need to address. But Maria is probably a better person to respond to this than I am.
Well, I'll just say very generally, I appreciate the question, but Lolly beat me to the punch, which is that as fabulous as the study group was, they're done now. And we're going to draw heavily on the great work that they did and the analysis that they left for us, but the Copyright Office has a much broader purview to look at absolutely everything that could be relevant to amending and or updating Title 17 generally. So that project that you described as one, as Dick mentioned, the Library of Congress has intense interest in video and film archives. There's the pre-72 study, which nobody has moved on yet, which we published after over a year of work. So all of these issues relate to preservation, but more specifically to your question, preservation where the works are at risk, and where libraries and archives have lovingly preserved them and may in fact have only the only extant copy of that work in their collections.
Could you be more specific on the report that you just referred to?
I'm sorry, the pre-72 sound recording report? Is that? is a report that, where's June? Standing right here. So June is one of the primary authors of the report, but at the request of Congress, the office was asked to do a study of pre-72 sound recordings, which are not currently subject to federal copyright law. And the general question was, should they be? And the conclusion of the office, after many hearings, roundtables, its own research, meetings with stakeholders of all kinds, basically concluded, yes, it should. They should because if to the extent orphan works legislation is passed, if 108 is updated, as the law develops, those at-risk recordings, in many instances they are at risk, would be subject to all of the limitations and exceptions going forward. So it's on our website, copyright.gov.
Okay, Eric?
Eric Schwartz from the law firm Mitchell Silverberg, but to address the question that was asked, I'm also on two advisory panels of the Library of Congress, one on film preservation and one on recorded sound preservation. And worth mentioning is that the Library of Congress, with a wide swath of representative organizations on preservation, libraries, archives, and the like, in both film and sound, have done studies on film preservation, 1992, and on recorded sound preservation a few years ago, with, in both instances, a national plan to address preservation and access issues of multimedia materials, film and sound. The library's recorded sound preservation national plan, I believe, is supposed to be released actually next week, several years overdue by the library, but coming out. And more to the point, the question has been raised many times, why only a study on film preservation and not also on video and television materials and other media? And the library has done some additional studies, and there is definitely a call to revise the studies, not just to limit it just to film materials, materials printed on film, and I think that will be an ongoing future effort on video material preservation as well.
Other questions? Yeah.
I'm Eric Harbison from the University of Colorado at Boulder. Going back to Mr. Rudick's point about where does this fall? Where does this fall in the legal landscape? I want to ask about at-risk recordings of a different sort, and that's the recordings such as the soundtrack from the movie Up, which is currently, last I checked anyway, unavailable in any form that a library can purchase. It is available through iTunes, it is available through Amazon Download, but it's not available on CD, and because of the terms of the shrink wrap license, libraries are unable to acquire them. If you look on last time I checked WorldCat, the recording is not in any library. So libraries will not have the last extant copy because we won't have a copy in the first place. I'm wondering where that falls in the legal landscape. I realize it's kind of complicated.
We really don't know where it falls. It's a damn shame, I'll say that, isn't it? But, you know, Section 108 was not set up as a collection building section. It was really set up on making reproductions and distributions of things that were already in the collection. So maybe that's something we need to ask Maria for the office to at least consider when there are and this isn't the only one. We've heard of older films that cannot be purchased, too, that the libraries have never had. So maybe we need to make sure that there is some potential for collection building when things are simply unavailable in terms that a library can acquire it and preserve it.
Well, there is one exception to the rule that we weren't concerned with collection building, and that's the website, proposed website exception. And there, the problem is, I don't know if you consider these websites to be part of culture, but for better or for worse, I suppose they are. and you know, they change so quickly, and the people who create them have no interest in preserving the old versions. In fact, if you're a politician, maybe you have every interest in destroying the old versions. So that's, I suppose, the one exception to our not focusing on collection building.
Okay, yes.
Yeah, I'm sorry, can I have a follow-up question, which is to Maria, which is, there is a collection building provision, it's library deposit, right? So can't the Library of Congress demand the soundtrack?
The Library of Congress can do that through legal deposit or mandatory deposit, as we call it. But I think, Eric, who I've met through the pre-72 discussion, if I could guess your follow-up to that remark, it would be, that's great for the Library of Congress, but there are many archives and libraries across the country that are doing an amazing collecting job and need help. Is that right? Mm-hmm.
Well, right, because if the Library of Congress has it and they can preserve it for the future, that's great. But if I don't know how well that would play out as far as policy if we want the Library of Congress to be the only institution that is preserving an item. I don't know. I admit I don't know whether the Library of Congress has gone to that step of demanding a deposit copy of things like the soundtrack to the movie Up. One of the problems is
I think if they haven't yet, that they're writing it down now.
Right. That's my best example of a recording at risk. But there are many others. Certainly, there's the Oscar winner and there's the Grammy winner that I know of. But there are also a lot of grayer recordings that the Library of Congress may not even have on its radar, right, and may never know to ask for a deposit copy of.
Right. So these are tough questions, and I would just say that I think I think there is some congressional intent that the Library of Congress be able to do things that others can't do. I understand on the other side, as I articulated, the concerns of other kinds of archives and libraries that aren't necessarily the national institutions. And I would also understand and acknowledge that sometimes the federal institutions aren't the most nimble institutions in terms of being able to implement vision. And I think that's why, for example, the library is very interested in trying to figure out ways to network in the digital age, connect portals, and do other things, all of which requires a more nimble Copyright Act. And so one thing I didn't say but should have said and would like to say in light of Jane's remarks is that in addition to 108 reform, many of you know that we are also very currently working on orphan works again. I think good members of Congress would tell you that legislation takes multiple Congresses to enact. And so while I've heard quite a lot of feedback about how frustrated people are that we don't yet have orphan works legislation, I don't think we're that off course in terms of the deliberation on that issue. And we just closed the first round of comments on orphan works and mass digitization for the first time, asking about the framework for mass digitization. And for us, and I'm sure for a lot of you, all of these balls in the air connect. You know, the dotted lines are very obvious to us. So 108 and orphans and mass digitization and licensing and collective licensing and fair use, they're obviously interrelated, and they all form kind of the tapestry that would make for comprehensive updates to Title 17. So that's why we're here.
There's a question here. Okay, other questions? Yes.
One of the things I've noticed in most of the recommendations...
could you identify yourself?
I'm sorry, Shelley Warwick, Touro College, New York, is that almost all the requirements for the things is still for on-site use. And I think in an age where so many scholars now, you know, especially with budgets, do not travel, the ability to access things that could be easily made digitally available or streamed, or also for handicapped people who have difficulty traveling or getting to sites, that it seems to me that it's staying in a very old framework not to allow off-site lending, off-site use, or, you know, with, you know, obvious protections for non-copying. But I think that to stay, it's like making yourself already outdated as you go to revise, is to keep that on-site use requirements in so many of the recommendations.
don't know if that was really a question, but thank you. Other questions? Yes.
I'm Dwayne Butler from the University of Louisville, and my question is for Maria. We've had a lot of conversations, and I like fair use a lot, right? So I don't think it's necessarily a request for a lawyer to use it, but I do think there's some necessity for other statutory exceptions. And my question goes back to the point that you've made, and I've been on lots of roundtables and things. And I always make the same point, so I'm boring. And the point is, how do we take this whole conversation that we're having today and really make it that simple thing, right? Because I'm having my car fixed last week, and my mechanic asked me about copyright law. So how do I make that conversation something, that simple conversation that my librarian colleagues can do all the good things that they do in light of all the conversation we've had in the first hour? So that's the question for you. How do we move that conversation to the simple framework?
That's a huge question. I think it makes me really happy that your car mechanic knows about copyright law. There's no question. I mean, you're reflecting what I think we all know and have either said out loud or have thought about kind of intuitively, which is copyright is no longer a field of law that is reserved to experts for conversation. We need technical experts because it is a legal framework that we're discussing. But people are interested and frustrated and want clarity and want information, and either they want to be able to do what they want to do without regard to it, or they want to know how to move through the system in a way that is lawful and respectful. And I don't think we're alone in this challenge. Other countries are facing the same thing, but we as a nation have to figure out a way to make copyright more accessible. And the government certainly has a role in that, whether through education, through public offices like we have, and the Patent and Trademark Office also has, through curricula possibly, through unsticking copyright in the marketplace, moving through gridlock, having licensing systems that make more sense, that are easy. So that's a huge challenge, but you're right to kind of raise it early in the morning.
What did your mechanic want to know?
I think he was curious about the software that's embedded in the black box in the car, right? So I mentioned the iPad and the Lexus. Like who signed up for that thing?
Okay, thank you. We're going to cut it off there. Sorry, but a lot of the questions are also relevant for the next panel, so there'll be another opportunity to ask questions. We're going to take a 15-minute break just so people can get up and get something to drink and stretch their legs, and we're going to reconvene promptly at 10:45 because we really want to try to stay on our schedule today. Thank you.